Well, basically, I have experts on this audience that know more about the Starbucks case. I'm looking at you, Hans. What we're trying to do here is, where are we going? Maybe one back.
Sorry, it's, oh, okay, no, sorry.
All right. Yeah, what we wanted to show you today is, how does the European Commission arm's length principle, if we can talk about that, is it really an arm's length principle that they have invented? And what can we learn from cases like Starbucks in that context? I have a personal view on this, but I might be completely wrong, and I'm happy to also invite you, Hans, and I see also Gunnar. You guys have a lot of experience in these areas for your opinion. And actually, I was hoping that Marina would be talking now. I'm not sure whether she's still there because she has really gone through all this in much more detail than I have. So I'm now a little bit stuck, but everybody knows the case of Starbucks. Can you go to one slide further, please? Yeah, I'm just a little bit out of touch here. I was not prepared for this, to be honest with you. Rosanna, where is Marina? How long will it take?
She said she will be 5 minutes.
Okay. Okay. Yeah, basically what was Starbucks doing is what I would refer to under, basic rules of deferral from a US tax point of view, is to create a structure whereby it effectively is able to park income, which is not yet taxed in the US, in a structure that is effectively above this Alki UK company. And the way they did that is they had an arrangement with the Dutch authorities around the pricing of beans, on what they had to pay for the green beans and how they would benefit in the Netherlands from running it through the manufacturing activities. And the second part is for all the know-how for roasting and the brand. So there were basically two effective streams. Rosanna, can you go back? Okay. There were basically two effective streams of revenue finding its way up to the UK entity that was used for the deferral system. The trigger, if I'm not mistaken, was also in the UK that Starbucks was a company that was making quite a lot of money revenue in terms of their business. They were announcing that in the market. And if you looked at the effective tax rate or the effective taxes paid in the UK, they were not paying a lot. So essentially, the EU Commission stepped in and was looking at whether this company was playing around with its model and whether the Dutch government had effectively given state aid as defined in the discussions we had before to basically Starbucks. Is Marina there already? Because I would like her to talk about, not the next slide, but can you give me the next slide? This is more the technical information about how the structure looked like above the company called Alki LLP in the UK. So if you look at, middle of the page, you see a lot of CV structures, which are partnerships in Holland, and ultimately the parent sitting in the US. The mechanism that was used here, as I mentioned before, is a deferral mechanism. What does it basically mean? It means that under US legislation, if you have a certain way of maintaining your income outside of the US, you get a deferral of taxation. So to the extent you have income that in principle is subject to tax in the US, you can defer it for a while. And in these companies have done this for many, many years. So the deferral became almost like an exemption, but it was also clear that if ever this income would be remitted or deemed remitted back to the US, it would be taxed under the normal taxation rules of the US. If you overlay to that basically the model, the know-how that was created by Starbucks US, including the brand and the people functions of, this whole DEMPI associated with the brand and the knowledge of how you run a business like this, including the, finding the beans, etc. All these functions to a large extent were in the US. So the real question here is, has the European Commission gone on a state aid approach to basically say, well, your pricing mechanism is not right, or Dutch government, you are effectively given state aid because you have not applied the correct pricing methodology in this setup? I have personally a question in this area, and I would like, lacking Marina momentarily there, I would love, Hans, if you have a view on this by chance. Do you feel that the EU Commission was stepping in at a point where, in essence, the one that is really giving the benefit, if you assume for a minute that all the critical functions associated with, say, the exempt income from a Dutch perspective, is really allocable to the US, and thus they're stepping into a discussion where actually the US is giving up for, the deferral period, its right to tax? Do you have a view on that?
Yeah, I have to dig in my memory. I didn't read it again for this session, but what I do remember is that the first court actually looked at also the principles of international taxation and compared those with the approach of the European Commission, and based on that, more or less concluded that it's probably not a question of state aid here. For what I know from the case, when I dived into the case a couple of years ago when it was started, is that at the local level, the taller manufacturer, that European Commission noticed that there was a depreciation of inventory, and yeah, that's a strange thing for the taller, that you have depreciation, and that would probably lead to the conclusion that has probably also helped with the way European Commission attacked this case, and but that as the situation as described was probably not as pure as it was described. So the facts were not as good as they looked on paper. Let me just call it that way. But the details, I didn't read the case before. So I didn't read it before, but not specific for this session. So I don't recall the Gunnar probably, some facts about this case, or any other of the participants.
Okay, no, I can, I made obviously an assumption here, Hans, that, some of the activities, if you look about brand, for sure, that has stemmed from the US. If you look at the operational model, it has been designed in the US and then exported. The big question is obviously if some of these functions in subsequent years after it has already arrived in Europe, if you will, whether maybe some of these functions have also been performed at the level in the UK or in other countries. That can create then obviously a question around, do you have a marketing intangible also in those countries? And as a result, yeah, then you can have a discussion about fine tuning of the intercompany relationships, and whether at that point in time, the Dutch government is giving too much, benefit, and thus is not interpreting the arm's length principle.
Wasn't it the case that the first court said something that they believed that it was in line with the recognized international tax principles? And then it's the matter probably that, as you know, because you in the transfer pricing practice, you see many situations where paper is paper, but the facts seems now then to deviate from the paperwork. That was a little bit here also, but the first court, if I recall well, said something like, yeah, it seems to be in line with, and still the Commission believes that another approach, international tax rules are interesting, but that there should be a pan-European, pan-EU approach on this topic. The European, like we call it, arm's length principle, which is different from the EU one. But that they didn't prove enough that, yeah, it was different. I believe the same things have been said in Apple, but I don't recall which wording they used in this case, because I didn't. The last time I read this case has been a year ago, I think.
Yeah, Hans, I think you're right on the right track. I think Marina is there. We'll go to the next slide, but you will see in this section that yes, in the first instance, the courts were sort of saying, yeah, you're following the system that you have in Holland, so you're applying or abiding by the law, if you will. But then there is a subsequent list of arguments coming in, and one of them says that there is an incorrect way of designating the BV as a low-risk manufacturer, i.e. that is already an indication that maybe that manufacturer has a higher risk and thus should have a higher income. So that's a discussion at that point. Marina, do you want to take that point from here and take us through the slide with the red and green, which is, I think, next slide?
Yeah. Okay, so here we have a comparison on what is the Starbucks case from OECD approach and what was the Commission saying about the Starbucks case on the arm's length principle. So basically on the OECD side, you see that Starbucks Netherlands was acting as a toller, was performing roasting activities, and it's good to remember there are two companies in Netherlands. So we have Starbucks Coffee and Meijer BV and Starbucks Manufacturing BV. Manufacturing BV buys green coffee from the Swiss subsidiary company, and then based on a green coffee purchase agreement between them, it does the roasting of this green coffee and mainly sells roasted coffee to affiliate and non-affiliated parties. And so this roasting is done through a certain know-how. This know-how is done by Alki LP, this partnership in the UK. This know-how is owned by that, and the license on to Starbucks Manufacturing BV through a roasting agreement. And there are two main transactions. So Starbucks buying green coffee and the royalty payment to the UK subsidiary. And here in the OECD side, you will see that the choice of method was the PNMM. It was a low-risk operations on SNBV sites, and the level of compensation was a markup on total cost from 9 to 12% based on a benchmark performed. What the Commission is saying actually is that, okay, the Dutch system, as Raymund was rightfully mentioning, as the constitute reference system, and the acceptance in the APA resulted in lowering BV's tax liability under this reference system of the Dutch law. And thus, they will use the arm's length principle as a general principle of equal treatment in taxation. And a second thing, a second argument of the Commission is that the APA incorrectly designed SNBV as a low-risk manufacturer. And in their revenues, it demonstrated the roasting is not the main source of income, but rather it derives most of these profits from reselling function, like that is called logistic and administrative service. And this reselling function, it's represent a source of this profit since 2010. So therefore, the Netherlands should take these accounting profits with no deduction of the royalty payment to Alki from this licensing. And what was accepted by the General Court? So again, this arguments by the Commission. What was actually accepted by the General Court is what you see in green. So the General Court said, yes, the Dutch corporate income tax system is a reference. And yes, you can use the arm's length principle as a general principle for equal taxation, but the Commission did not sufficiently prove that the APA and that the remuneration of SNBV as a toller was incorrect. So in the end, this was rejected by the court. So the commission grounds did not stand. But what's important here is to say that the court did acknowledge the use of the arm's length principle, regardless of the fact that the arm's length principle was not inside the Dutch corporate income tax system at this point in time. So regardless of it, if it's inside the law or not, you should the commission can apply the arm's length principle as a matter of equal taxation treatment. Maybe next slide. So what is the background on the EU Commission approach to state aid? So the EU Commission has a certain difficulty with tax ruling cases. So there are certain countries that do not contain the arm's length principle in their law at all. And there is since there isn't a sort of arm's length principle in some jurisdictions, there is an invention of what we call the commission arm's length principle during the course of investigation. There was no early appearances. The only reference that the commission does is to the Belgian Coordination Center's case law on the court side, and it's used as a tool to assess whether a selected advantage has been granted in a state aid case. So they use the arm's length principle to assess the selected advantage criteria. And the central issue, one of the central issues that we identified for this commission arm's length principle, is that they try to compare members of a multinational group as standalone enterprises, disregarding synergies that might occur for being part of a group. Next slide, please.
Marina, one second, please.
Yeah.
If you go back to the former slide, and Hans, you are very knowledgeable about European law in general and tax law in particular. If I look at point number one, the rulings seem to confirm or conform with OECD guidelines, but national law does not contain the arm's length principle. We do know that Holland is sort of signing up to the OECD guidelines. Is that really an issue? Is this really a problem, or is it? I think this is the fact that it is not a law is a formal principle, but to the extent countries sign up and commit to follow the guidelines in determining the profit of a company in Holland in particular, goedkoopmansgebruik, then I think that to me doesn't seem like a critical aspect. Not sure how you think about this. Is this formality an issue?
No, we know Article 8b since 2002, I think, which contains what I believe is an arm's length principle, and we only included it in our corporate income tax law because it could be questioned whether we have used the arm's length principle, and since in the Netherlands tax treaties supersede domestic law and all tax treaties contain an arm's length principle article. Now, Raymond, I'm fully with you. This is clearly a nonsense argument.
Okay. Okay. So in the discussion we had in the plenary session around cases that we can expect to come, where there's a lot of discussions with tax authorities on a lot on arm's length to begin with. It just leaves the door open for the EU Commission to still come in.
No, they're still considering the steps, because although in all cases they didn't really lose, they still have possibilities to continue with the state aid discussions, but there's no clear light with respect to the MIP, the market economic investor principle, because it's all about the MIP and it's not about the ALP. And so the last word hasn't been said, but nevertheless they have a bad position to continue with going into cases. Actually, Ms. Verster, in Danish, you pronounce her name as Verster, she announced that new regulations, new rules, new laws, EU and global, like Pillar 2, for example, seem to be the solution. So there will be new cases, I'm fully sure, but I don't think we will see a tsunami of new cases at all.
I have a bit of impression that maybe this is a political discussion now.
It was always been a political discussion.
Yeah, I know. You know, if you really look at it, I think the commission is obviously giving a lot of shots in front of the bow, and they're trying to aim at the bow. But the message, I think, is more towards the states: be careful on what you give away, because we do have authority to go and challenge, basically, if you give too much away, which is a distortion of the economic principle that we want to have a level playing field within the European Union. I think that seems to be sort of the game plan. Clearly, we need to be aware of it. I personally don't believe that there is a new arm's length principle as such.
You know, the MAP is the origin of the market economic investor principle is from competition law and is actually developed by the European Court of Justice to tackle situations of public-private participation, where the government and situations where private parties and public parties work together, where public parties probably prefer private parties from its own state in those kind of situations, and therefore there was some thresholds being developed to exclude foreign private parties. And if you think about the background of the MIP, it also gets clear that one of the main questions to be answered by the European Court of Justice, not the first court, is going to be if the MIP is an alternative. Now, first of all, is anyhow an alternative, because the first court said we don't reject the MIP, but you have to prove it's better. But if you go back to where the MIP stems from, it's actually not possible to use it at all for those kind of situations. So I'm not that negative on this topic.
Yeah, the statement I made was, I think there might be still cases coming. I would agree with that, because they want to keep the political pressure on.
Yeah, Nike is still pending. Nike is still going to be a case, for example.
But it is still, you know, a process of getting more control over countries.
Yeah.
To not give away, you know, in a sort of unbalanced way, if you look at the level playing field in all the countries in the EU. That's my gut feeling.
Yeah.
The way I translate that from from a corporate perspective is that I still believe that if you do a proper job, bearing in mind functionalities, bearing in mind value creation, bearing in mind pricing models that build on that, i.e., you know, read the OECD guide and make sure that you sort of, you know, within the ballpark of what was defined there. I think you still have a sound basis for operations. The other question is, do you see, and maybe Gunnar in Germany or Michael, if you see that in your world, do you see any tax authorities nowadays coming up with, let's say, special deals? Do we see special deals at all? Or is this thing where, you know, we are all a bit older, but if you look at history, there were always nice sweetheart deals. I don't have an impression that we see many sweetheart deals.
Only in Switzerland, Raymond.
Then I'm in a good country.
The 10 years period description of the onshoring is probably, no, not in Netherlands.
No, but I think
Germany neither. We were never really too fond of it, because our constitutional court would really try to intervene as much as they could.
Yep.
But there's really no drive to do that in any way. As I said, sometimes if you try to circumvent state aid laws, you would have seen some weird behaviors on the administrative side, but not really a sweetheart deal as such. And I think we're more down to trying to get things through state aid and are still powerful enough within the EU to sort of push this through where we think it's needed.
Yeah, and I think your statement earlier, Hans, about that Switzerland still allows, or maybe it's a better country for those kind of sweetheart deals. I think those days are slowly but surely also over. If you bear in mind that obviously the EU has put a lot of pressure on Switzerland with its special company structures that they used to have in place, like mixed companies and principal companies and all that, based on law or circular. All these have been abandoned. There has been a major change in the law, which was voted upon twice by the people to get it changed. Now we have the change, and what we're sensing is that especially the federal authorities are somehow playing watchdog over what is happening at the level of the cantons. To put it in a different perspective, the federal authorities are more and more in advance providing the cantonal authorities with a sort of a heads up. You know, I don't want to call it a warning, but more like a heads up. They sent letters to the conference of tax inspectors in the cantonal levels, basically telling them what the federal authorities feel is the right way of approaching it. And they do, at federal level, feel the pressure from the EU Commission. And they feel the pressure that if via the back door they try to get again this, you know, economic advantage to pull companies into Switzerland, and that they are thus competing in a not so good way, that they will have the pressure coming from the EU. And I think the authorities in Bern are a bit wary of that, and they don't want that conversation, because this is a conversation that has been going on for the past 15 years and they're dead sick of it. So they sort of want to play, you know, the good cop or the good child in this game. So maybe there's still a pragmatism, but no longer sweetheart deals, I would almost think. But maybe I stand corrected at a later stage. Maybe you have other experience, but that's what I see happening momentarily in Switzerland. And we also see that, you know, the entrance of new companies into Switzerland has drastically reduced. If not,
in the Netherlands, yeah,
it has reversed. Companies are potentially even deciding to leave with their activities if that's you know, not that too high cost of doing an exit here. So I think the EU pressure stopped a lot of things, and I think with the Commission now, as I started off with, you know, the shot in front of the bow, I have an impression that we're seeing other countries also, you know, keeping their gunpowder dry rather than giving sweetheart deals. I know, Michael, they did not prepare you for this, but would you be in a position to comment on this from your personal perspective? You're obviously working for a Swiss-based company. Do you see anything different than what I just said as an expectation from the Swiss authorities, or how would you judge that?
No, I think that's I thought you gave a very interesting summary, actually, Raymond. I mean, we still obviously engage in very active conversation at the cantonal level, but as you say, there is definitely an increasing role for the federal voice in that conversation. Yeah. So, you know, we still get rulings. Whether you would classify a ruling which is broadly in line with what you might expect the law to say as a sweetheart deal or not, I'm not sure you would. No. I think you would say, actually, that's just clarifying the rule of law, and therefore I would agree with you. We just do not see this very much at all. It's bespoke nature of our rulings, etc. Switzerland and in Asia particularly, but nothing more.
Okay. No.
It's interesting is if you guys would be interested, once you have a free weekend, dive into the Brexit negotiations and dive into the discussions going on with that respect. And you will notice that one of the breaking points with respect to the Brexit is that the EU wants the UK to also accept all, which they actually already accepted, the direction like ATAT 1 and 2, but that they will continue with it, and that they will also accept the European Court of Justice and the state aid criteria to be applied on the UK after the Brexit. So that's like a marriage where you say, okay, whenever we are divorced, you're allowed to do your living, but you're never allowed to get another guy or whatever, or a woman with a panel. So it's like those kind of situations going on over there, and that gives an idea about the difficulties the state aid is and the idea what the European Commission wants. Actually, there has been a publication not too long ago, sort of like a white paper for the European Commission, where they want to apply state aid in relation to third states, but that's of course impossible. You cannot do that. Where the import duties to the European Union will be partially dependent on the question whether in the state which produces the products, aid is going to be provided. For example, Chinese solar cells, we all know that there is some money from the government in those situations. The European Commission wants now, it's in the first phase, the second phase will be in 2021, that in those situations they will be allowed, so they will be enforced to levy additional import duties in situations where the other state provides aid. So they're still working on it, and they're still trying to expand it to Switzerland, to the UK, and to the rest of the world.
It's the America First principle, which is EU now. I can reach over the border and now start dictating on others. But I think it's the political arm, it's the economic arm. And it's a way against protecting the inside market. It's a protectionistic approach. And I think if you look at the Brexit that you were referring to, I think that's again the political dimension of, all these information that we have heard in the front end of all these discussions of going outside of the EU. Does Brexit, the UK has said, hey, now we're going to attract companies again. Now we are free to do that. We reduce the tax rate and we make it interesting again for companies to come in. We're no longer obliged to stick with these EU rules.
Yeah.
Hey, that's, selling the skin of the bear before you shot the bear is what we say in Holland. And that's probably the boomerang that is coming back on that one. Okay. Marina, sorry, I hijacked now a part of the conversation, but I think if we go to the slide that you wanted to talk about, I think there is some aspects of that coming back in again.
Raymund, Marina has stepped out actually of the conference. She will no longer be part of it for the rest of the evening.
Okay.
So we continue.
All right. No, this was not the slide. I think this is more, that was what. Can you go back?
One more back?
Yeah. I think this is just, where we try to make the comparison between how the OECD transfer pricing guidelines compare to the Commission's alternative way of looking at an arm's length principle here. We see this point of the case of Forum 187 for the Belgian Coordination Center at the time. But I think what we just concluded a minute ago, there is not really a new arm's length principle that was introduced by the EU, by the Commission as such, at least from my perspective. I think they missed the ball on really the functionalities and looking at a way that is a government really giving a benefit to a company by undercutting on what should have been there given the functionalities. And I don't think they made the case clear enough to get that point one. So, I think we discussed this already, unless somebody has a comment on this. Hans, I don't know whether you have any further points because you were already kind enough to step in on this one, but I think it's, from my perspective, it's a tool, it's a way to shoot, but whether they will stick, that's a separate question. Also, the fact, if you think about it on the case of Apple, I would almost, I'm probably too simplistic, I would almost be be repeating what I said before, and I think in the Apple case, it's even more prominent that all the design of, iPhones, etc., the whole marketing, the whole product promotion, the way they present themselves, it's a US invention. But, yes, we have manufacturing in other countries, but it's very much controlled from the US.
Do you recall what Philip Baker mentioned about it?
Sorry?
Did you recall what Philip Baker, who runs the case for Apple, mentioned about it once?
No.
He said something like that the discussions before the court case were always in that direction, that in the litigation strategy of the European Commission, they stated again and again that all the IP was in Ireland. How stupid can you be?
Yeah, and this goes exactly in the line that I was referring to before, because what is the functional proof of that? Do you have any proof that this is really the case? And even looking at it from the outside in, there is a hell of a lot that is going on in the US, and there is a hell of a lot going on in China on the production side. So we're talking about a sales model where you could almost say, the guidance that comes from the top down is almost such that even any Apple shop or a shop of Apple within a shop has to follow the rules of the game, and they are really very much controlled. There is almost like there is a handbook that tells you exactly what to do and what not to do. So there is hardly any risk left over, if you realistically look at it, for any local organization, but to follow the rules of the game.
Yeah, what you see in EU law very strongly is that in the Dutch law, whenever you go to the court, you have your primary position and you have your secondary position, which replaces the first one. If you cannot win the first one, you don't see it in this kind of situations. And the Commission had one possibility to be successful, and that's that in all these structures, they landed with cost contribution arrangement in Ireland, and then at a certain stage, they relocated the entity to Bermuda, wherever. And that has always been done with the cooperation of the Irish tax authorities. And that element could be interesting to tackle, but they wanted to go for the big fish. And that's why I think they lost the case, because they don't have that ranking of positions as we know normally whenever we go to a court.
Yeah, I think, it's definitely a fair point. But I think also what I find astonishing is that you don't recognize the American tax system. Because the one that has been sitting silent, in the sense of not silent, they have been objecting.
They were silent.
They have been objecting in the way that the EU Commission was obviously targeting all these US companies, which again, to a certain extent, has definitely a political aspect to it. But I think completely ignoring the right of taxation by a government, and the right for that same government to decide whether or not it wants to postpone that taxation, but not canceling it. It's the deferral system. And we all know all these big companies that were deferring until the end of the game, that they could, they held on to so many billions, especially if you think about Apple, all the many billions that they had in their bank account in Bermuda, quote unquote, for purposes of keeping it out of the reach of the tax authorities in the US. But still, that was a choice made by the US tax authorities, or the legislature, so to speak, because there was a 40% tax rate, and they wanted to give the companies an opportunity to have an effective tax rate, which was more akin to 2025 on the global scale, yes, at the expense of tax authorities outside of the US. But still, that was the stronghold of a powerful economic power called the US. That's quite a challenge if you're in front of such a such a position from a formal point of view, and you don't follow, you know, a proper way of looking at functionality, risk, you know, the traditional ways of how you look at it from a transfer pricing point of view, especially now with the latest OECD guidance after the BEPS project. So I think they missed out big time, and unless you have a case where even the taxpayer has done a bad job, that's when the taxpayer might lose. So yeah, you said it right, Hans. I think they went for the big fish and they came home dry and empty. I think that's
there actually says in the Apple case to the States, Ireland, make sure you claim that 13 billion euros, and other states sue Apple also and make sure that you get whatever you can get on that local state level.
horrible. Really horrible. Bad governance, I would say.
Yeah.
Hey, what can we do about this? I think we're getting closer towards the end. Are there any questions out there that we should consider? I have not followed the chat now, but if there is anybody that has a question or has a comment on this topic in particular, where do we see the world going around state aid cases? I think we already said to a certain extent that we expect that more cases to come. The question whether they will be successful, in my humble view, will be a function of whether there's really a good or a bad case in terms of facts underlying. The rest is up in the air, whether the EU Commission wants to be very political again and tries to aggressively protect its tax base or its, you know, its level playing field within the countries, which I think they have already achieved to a certain extent by shooting at these companies. People are more cautious, governments are more cautious because they don't want to be dealing with the Commission as such. So somehow the shot in front of the bow seems to work. Is that the strategy? Could well be.
Closing remarks.
Okay. Any points? Otherwise, Rosanna, I think we're going.
Yes, for just a quick closing session. They're already done on the other side, so they're waiting for us.
Okay, then, unless people have questions, comments, I would like to say thank you very much for this unexpected pleasure, and we'll be talking on the back end. Thank you.